employment agreement. The agreement is the binding factor between the employer and the employee.
A senior VP of a reputed bank was seen to be abusing and scolding his subordinates for not meeting sales target.
Under the SC/ST Prevention of Atrocities Act.
These days, most of us spend a lot of time either at our office or at work than we do at our home. But unfortunately, not everyone has a very positive and a fulfilling experience. Oftentimes, there are disputes between an employee and an employer on various aspects such as discrimination, wrongful termination, wage disputes, work-life balance, and many more. But these issues are very common, and therefore, it is very important for both the parties to understand the legal rights and obligations to establish a fair and a productive workplace. Hi, this is Ashneer from Vakilsearch, and in this video, we are going to discuss some of the most commonly faced legal disputes between an employer and an employee. And to give us more insights on the rights and the legal remedies for both the parties, we have our expert, Advocate Damni, with us today. Hi Damni, thanks for joining us.
Hi Ashish, pleasure's all mine.
Superb. So Damni, to begin with, can you tell us what are the basic legal obligations that an employee and an employer has to fulfill when they decide to join hands and work together?
Sure. I would say the employment agreement. The agreement is the binding factor between the employer and the employee, and it is the duty of the employer to draft a legally binding contract, and it is the duty of the employee to read each and every term that is there in the employment agreement. The agreement should not just talk about the date of joining, the designation, or the compensation details, which are generally there. It should also talk about some minute things like the lock-in period, the termination clause, the appraisal period, the incentives, and non-compete, non-solicitation, confidentiality and data privacy, and also notice period. What happens if the notice period is not served? Everything in detail.
Understood, Damni. Makes a lot of sense. So I'll give you a couple of instances. These are some of the incidents that went viral on social media recently. I'll explain this in brief detail. You can let us know what legal remedies we can take on these instances, right? So for example, in one of the videos that went viral on social media very recently, a senior VP of a reputed bank was seen to be abusing and scolding his subordinates for not meeting sales target. If this happens to one of our viewers who are viewing this video, what do you think they should do in these cases?
Well, for any use of abusive language, the companies will have a whistleblower policy and the employees can take action through the policy.
Just a follow-up question on that. Can you explain what do you mean by a whistleblower policy?
It is an internal policy in any organization where employees can come and raise complaints or concerns about the working of the organization itself.
Should I assume that it will be anonymous?
No, it may not be. If the internal policy says that it will be anonymous, then it can.
Okay, understood. In another video that went viral, Ashneer, who is the founder of BharatPay and also the former chief executive officer, mentioned that even if you don't serve your notice period fully in an organization, the company cannot take any action against you because he said it's legally not binding. How true is this statement?
See, I'll explain this in both employer's perspective as well as employee's perspective. In an employer's perspective, they do not really want to litigate against an ex-employee who do not serve the notice, but they will definitely take action in case if there is a data privacy threat. But in case of an employee, I understand that there is right to livelihood, but the repercussions are also there. For example, if the PF portal is not updated with the date of relieving by the previous employer, then the current employer will not be able to update the date of joining as well. So these are things that you need to keep in mind, like you will not get the experience letter, you will not get the full and final settlement. All those repercussions are also to be kept in mind while not serving a notice period by the employee.
Talking about serving notice period, this is a very common problem faced by all employees. When they try to change jobs, they attend interviews and the companies expect them to join immediately, whereas the existing employer insists on having a 60 to 90 day notice period. So there is a clear conflict here. So in such situations, what do you think an employee can do?
This is what I mentioned at the beginning, Ashish. Employment agreement is the key. If the agreement says that the notice period can be waived off if the employee pays the salary in lieu of the notice period, then it can cover them up.
Okay, Damni, I also want to ask you one more relevant question. So after COVID, most of us started working from home, and work from home is kind of the new normal in these days. So when employees work remotely, what are certain policies that an employer has to have in place to make sure that his data, his IP, his assets are all protected?
More than policies, technology help employees keep their data safe. They don't allow the employees to download data or migrate data. In fact, they don't even allow them to access the portal through a VPN and all that here. So if at all these facilities are not available, then the new normal is to have a work from home policy and also keep some money reserved with the employers, and that can be settled during the F&F.
So, Damni, what if someone feels that they are terminated wrongfully, or they are not given a promotion based on their caste, their religion, or their cultural background? In such situations, what are certain legal remedies that an employee can seek?
This is not a employer-employee issue, Ashish. This is a social issue. Yeah, if there are such discrimination based on the caste, then the employee can file a criminal complaint against the concerned person or the management under the SC/ST Prevention of Atrocities Act.
I mean, yes, Damni, rightly said. I think this is more of a social issue than an employer-employee dispute. I agree on that. Coming to my last question for this video, Damni. So, for financial markets, we have SEBI as the regulatory body. For all insurance disputes, we have the IRDA. For all property disputes, we have the RERA. So similarly, is there any regulatory body for all employer and employee disputes in India?
See, there's not just one. Starting from the labor codes to the industrial tribunals to the shops and establishment department, the payment of wages department, the gratuity department, there are n number of departments that helps employees to seek their remedy. But the knack is to find which tribunal or the department you need to approach for a concerned issue.
So that wraps up our discussion for today. Thank you so much once again, Damni, for joining us today. And as always, all your insights have been very helpful for us. Thank you so much once again.
Thank you, Ashish. Pleasure is all mine to be in this discussion.
So for all our viewers, I hope that you found this video to be helpful. And if you're able to relate yourself in any of the situations that we discussed, please feel free to call our expert lawyers and have a detailed discussion. The number is available on the screen. And if you also like this video, please leave a thumbs up and subscribe to our channel for more legal content.